Good day, ladies and gentlemen. This is Dr. Frel, your professor.
Hello class, good morning. Our topic today will be on crimes against chastity. So what are these crimes against chastity? These are those crimes involving sexual behavior. They include but are not limited to the following sexual acts such as adultery, child sexual abuse, prostitution, rape, abduction, and the like. Now let's discuss first adultery or concubinage. So this adultery and concubinage are crimes against chastity under the revised penal code of the Philippines, in which are referred to as sexual infidelity in the family code or marital infidelity in a general sense. And now class, who are guilty of adultery as provided in the revised penal code? Article 333 provides that adultery is committed by any married woman who shall have sexual intercourse with a man, not her husband, and by the man who has carnal knowledge of her, knowing her to be married, even if the marriage be subsequently declared void. Adultery shall be punished by prison correctional in its medium and maximum periods. When we say the penalty of prison correctional shall carry with it that of suspension from public office, from the right to follow a profession or calling, and that of perpetual special disqualification from the right of suffrage, if the duration of said imprisonment shall exceed 18 months. Now class, if the person guilty of adultery committed this offense while being abandoned without justification by the offended spouse, the penalty next lower in degree than that provided in the next preceding paragraph shall be imposed. Now class, please remember that only the offended spouse can initiate the action, but both offenders in adultery or concubinage must be named in the complaint unless one is already dead, where the fact must be alleged and which such fact must be alleged in the information. Otherwise, the information is defective and subject to a motion to quash or repress. Now class, if at the time of filing, the complainant has obtained a divorce abroad, although not recognized in the Philippines, he has no standing to file the complaint. If the complainant consented to or promoted the infidelity, he is stopped from filing the complaint. So that was for the discussion under the adultery. Now class, let's continue with Article 334 providing for concubinage. So any husband who shall keep a mistress in the conjugal dwelling or shall have sexual intercourse under scandalous circumstances with a woman who is not his wife, or shall cohabit with her in any other place, shall be punished by prison correctional in its maximum and medium periods, while the concubine shall suffer the penalty of destierro. When we say scandalous circumstances class, this might be something that is shocking, shameful, immoral, or disgraceful or indecent circumstances concerning this act of concubinage. And when we say destierro class, this means banishment or only a prohibition from residing within the radius of 25 kilometers from the actual residence of the accused for a specified length of time. So class, this crime of concubinage is committed in three ways. One is by keeping a mistress in a conjugal dwelling. 2 is having a sexual intercourse under a scandalous manner with a woman, not his wife. And 3, by cohabiting with her in any place, whether they lives together as husband and wife. So please remember also, class, that sexual intercourse is not an indispensable element in concubinage. When we say indispensable element, it might not be that essential or necessary, or it might not be a requisite for it to be an element in the case of concubinage. Then we have now, class, the acts of lasciviousness. Under Article 336 of the Revised Penal Code, these are those committed against a male or female in under circumstances of rape. Example, if there is no consent. Then under Article 339, these are those committed under the circumstances of seduction, and the victim must be a female. And as compared to attempted rape, both requires that there must be no penetration or not even slight, and more importantly, there is no intent to penetrate for this to qualify as acts of lasciviousness. So again, class, under Article 336, it provides that any person who shall commit any act of lasciviousness upon other persons of either sex under any of the circumstances mentioned in the preceding article shall be punished by prison correctional. Okay, now class, we have the case of qualified seduction. Now let's define first seduction. This seduction is the act of persuading a person to have sexual intercourse. And the law provides these elements that falls under qualified seduction. First, the offended party is a virgin, which is presumed if she is unmarried and of good reputation. Second, she must be over 12 and under 18 years of age. Third, the offender has sexual intercourse with her. And fourth, there is abuse of authority, confidence, or relationship on the part of the offender. This is accordance with Gonzalez versus Court of Appeals, or CA. Now, how about simple and qualified seduction? The elements include: one is if the woman is single or widow of good reputation, such as she is a virgin, and it is committed by any person. Second is committed by person in authority, a priest, house servant, domestic or guardian, teacher, or any person entrusted with the education or the custody of the woman. Third is the victim is always over 12 but under 18 years old, and the offender is the brother or an ascendant, and the victim may be over 18. Her age and moral reputation is not material. Now class, how about forcible abduction? When you say abduction, this is when the action or the instance of forcibly taking someone against her or his will. So in the case of forcible abduction, the element of sexual intercourse is present in rape and seduction, but not in forcible abduction. Thus, when sexual intercourse occurs, the crime is complex forcible abduction. So, elements of this crime includes: 1. The abducted is any woman regardless of her age, civil status, and reputation. Second, she's taken against her will. And the abduction is with lewd design. When we say lewd design, class, this is something that is lustful or lascivious or lusty design. Now, how about in the case of forcible abduction with rape? So the elements under this crime includes 1. The person abducted is any woman, regardless of her age, civil status, or reputation. Second, she is taken against her will. Third, the abduction is with lewd design. And fourth, the abducted woman is raped under any circumstance provided in Article 335 of the Revised Penal Code. Now, class, please remember that in the case of forcible abduction, where the girl is under 12 years old, the crime is always forcible abduction with or without the consent of the child. It's because the law presumes that the abduction is against her will. Now, in the case of consented abduction, gravamen or the essential element of the suit is the alarm and the disturbance to the parents and the family of the victim in the infringement of their rights. So it requires that the taking away of the offended is with her consent secured by solicitation or cajolery. And second, it is with lewd designs. And class, remember also that for qualified seduction, however, it requires in addition the crime to be committed with abuse of confidence, authority or relationship and offender has sexual intercourse with the woman. So again, class, in the case of the AXA or adultery, concubinage, seduction, abduction, and acts of lasciviousness, these crimes shall not be prosecuted except upon a complaint filed by the offended party or her parents, grandparents, or guardian. And in the case of adultery and concubinage, this can be prosecuted only if filed by the offended spouse. In such a case, class, pardon of the offended does not extinguish criminal liability except in Article 266, Paragraph C of the Code under the anti-rape law, which requires a valid marriage between the rapist and the victim to effect an extinguishment of criminal liability. However, civil liability is extinguished by express waiver of the offended. Now, class, in addition, the anti-rape law clarifies that the marriage must be valid, otherwise, pardon will be ineffective. Thus, if the requirements under the family code, says example, the legal capacity of the woman is lacking, the marriage will be null and void and the pardon will be ineffective. So, persons guilty of rape, seduction, or abduction shall be sentenced to, as provided in Article 345 of the Code. The sentence will include 1. Indemnify or compensate the offended woman. 2. Acknowledge the offspring unless the law should prevent him from doing so. And 3, in every case, to support the offspring. Now, class, on the case of rape, Article 176 of the Family Code confers authority over illegitimate children on the mother and likewise provides for their entitlement to support. And in addition, compulsory acknowledgement as well as support of the child is indeed proper there being no legal impediment in doing so, as it appears that complainant and appellant are both single. And the crime of rape committed by the accused carries with it the obligations to acknowledge the offspring if the character of its origin does not prevent it, and to support the same. This from People of the Philippines versus Namayan. While indemnity or the security awarded under Article 345 Paragraph 1 should be absolute and is never conditioned upon the financial capacity of the accused. So the accused cannot use his financial incapacity as reason not to support or not to provide the indemnity. That is from People of the Philippines versus Saluna. Now, class, Article 335 provides the when and the how rape is committed. So, rape is committed by having carnal knowledge of a woman under any of the following circumstances. First, by using force or intimidation. Second, when the woman is deprived of reason or otherwise unconscious. And third, when the woman is under 12 years of age, even though neither of the circumstances mentioned in the two next preceding paragraphs shall be present. So again, class, please remember that the crime of rape shall be punished by reclusion perpetua or life imprisonment. Now, whenever the crime of rape is committed with the use of deadly weapon or by two or more persons, the penalty shall be reclusion perpetua to death. And when by reason or on the occasion of the rape, the victim has become insane, then the penalty shall be death. Now, when rape is attempted or frustrated and a homicide is committed by reason or on the occasion thereof, the penalty shall be likewise death. And when by reason or on the occasion of the rape, a homicide is committed, the penalty shall be death as well. Okay, class, so that would be all for our topic. And for your activity, what program can you suggest to students like you for them to avoid being victims of rape or to be perpetrators of the crime? Or it might not only be for rape but for other crimes against chastity. Present your output in a matrix and submit it in the Google Classroom. Okay? Again, class, thank you for watching and see you in the next video.